This is UCL Uncovering Politics, and this week we're looking at international human rights law. Amidst democratic backsliding, the weakening of international institutions, and conflict around the world, can international law still be a source of hope? Hello, my name is Alan Rennick, and welcome back to a whole new year of UCL Uncovering Politics, the podcast of the School of Public Policy and Department of Political Science at University College London. We're looking forward very much to bringing you much fresh research about politics and policy over the coming weeks and months. And this week, rather than delving into a single new academic publication, as we often do, we're exploring in the round the ideas and career of our wonderful colleague and friend of the podcast, Professor Veronika Fikfak. Veronika gave her inaugural lecture as Professor of Human Rights and International Law here in the UCL Department of Political Science in the spring. And as regular listeners will know, we take such occasions as opportunities for some broader conversations. Veronika is co-director of UCL's Institute for Human Rights. Her career to date has included stints in Oxford, Cambridge and Copenhagen, as well as London, and she serves as an ad hoc judge at the European Court of Human Rights. She's also leader of two major human rights research projects funded by the European Research Council. Veronika, congratulations on your inaugural lecture. Congratulations on that extraordinary CV that I've just gone through. And welcome back to UCL Uncovering Politics. It's fantastic to have you on again.
Thank you very much. Thank you for having me.
So we're going to be talking about international law today, particularly international human rights law. You argued in your lecture that though international law appears to be under severe stress at the moment, still we should maintain hope. Before we get into that argument, could we perhaps just clarify the basics? When we're referring to international law, international human rights law, what actually are we talking about? I suspect that many of our listeners, even me to some extent, will be a little bit hazy as to what exactly we are talking about here.
So we're usually talking about international agreements, and that's essentially contracts between states, usually on a massive scale. So a lot of states signing up to a treaty or a convention, we call it, that binds every state, so creates an obligation for every state to respect specific rights of their own people or people on their territory. So, for example, there's, prohibition of torture. States will not torture. They won't use their police powers to torture people. We won't indefinitely detain people. And this is what states on international level accept. And then usually in specific situations, they can be taken in front of a court or in front of a quasi-judicial body. And that's where individuals turn to. But I want to say that states have discretion in terms of whether they sign up to some of these, and they don't have discretion where they're signing in terms of others. So, for example, prohibition of torture is an obligation that applies across, even to countries who haven't signed these treaties. So we have these exceptional rights like torture, like prohibition of genocide, that even if you haven't signed up to it, there is a prohibition of committing that kind of crime.
And where do those come from? How has that principle been enshrined such that it does apply even to countries that haven't signed up?
So those are what we call customary rules of international law. Usually they're called, even more specifically, jus cogens, and that means it's like a power or higher protection offered to individuals. And they come from practice of states, where states over time, even without something being written down, have come to develop the belief that that rule has to apply in international relations. And so this is why there are specific norms that we apply regardless of what countries have signed up to them in a treaty.
How far back in time does that go?
Well, a lot was generated, I would say, after the Second World War. So the Nuremberg trials here were super important because the question there arose whether you could actually try people for crimes that they had committed that had not actually been written into law. And so whether or not these rules could be retroactive. And the answer there was, yes, you could, because there was a common understanding. But I think the Second World War really led to a recognition of these rules as existing, even if practice beforehand was relevant to their development.
So that's a very quick hint of the history.
Yes.
How should we characterize the health of international human rights law today?
So I struggle with this question because obviously the title of my lecture was Hope. But actually, if you look around the world today, and even after I gave the lecture in the summer, if you turn on the TV, you've got a number of different conflicts that are in the news. We've got the question of Palestine and really starvation going on there. You've got Sudan. You have the war and invasion in Ukraine. So you've got a number of different hotspots, I'll say, where horrible things are happening. And so it's hard to talk about international law being in a good place. I've also just come back from Geneva, the UN in Geneva, where the US last year pulled out of the Human Rights Council and said it wouldn't pay its budgetary contribution into the UN system, which of course means that the institutions now, of human rights institutions in the UN, are really struggling to perform their work. So when you put those kind of things together, and it's not only the US, we've got a number of other countries in Europe that are pulling out their budgetary contributions. When you've got these kind of things happening, in addition to the question of countries or leaders being outspoken about the fact that they want to undermine the authority of international institutions, those kind of lead us to be in a place where you're kind of sad and worried about the state of international law. But so the study we created, and I can talk about that later, led us really to the conclusion that when you look at the nitty-gritty, then actually this famous statement by Louis Henking that most states obey most international law most of the time still holds.
Mm-hmm. And does that apply all around the world? Do I remember that the particular focus of your research was on Europe?
It was Europe, yes.
Yeah.
Yes.
So do you want to say a little bit about that research first, and then maybe we can explore how far it extends beyond Europe as well?
Sure, thank you, yeah. So we looked at, we wanted to understand how countries around the Council of Europe, so it's 47 countries, we counted Russia because it was in our data set as well up until 2022. So how 47 countries of the Council of Europe respect the judgments of the European Court of Human Rights. And really the court is there to take a treaty that we mentioned before, like the European Convention, apply it in practice and say, this is how country X has violated these persons' rights, and then this is what you need to do in response. And we were looking whether countries actually fix the violations that they have already committed. So not whether they act preventatively, but whether they fix once an international institution has identified a problem. And we found that in 85% of cases, countries do something in response to a judgment, that they obey the court, that they pay the damages, but that they also undertake certain measures to ensure that the behavior or the conduct doesn't happen again. I want to say that this wasn't consistent across all countries. So when we're talking about 85%, that's obviously an average. So Russia in that graph was only 39% of its judgments complied with. Whilst you've got a number of Western countries, even Czechia was at 100%. So you've got that discrepancy between the different countries. Azerbaijan was also extremely low, I think around 17%. But overall, the average was around 85.
And why do countries comply most of the time?
So different things. First of all, we found that the major reason where compliance doesn't happen is capacity. So countries either don't have the money to do it right away and they need a bit more time, or they don't know how to do it. And actually, once you share with them ideas for how to do it, so for example, there's a lot of cases where you've got prisoners living in very poor conditions in a prison, and that's a violation of the European Convention. And so the question is, do you go and build a new prison, or do you actually reduce the number of prisoners? Do you, for example, change your laws so that you don't put everyone in a prison, but you actually just put the most serious offenders? And so you've got this kind of spectrum of different measures that you could take as a state, but if you don't know them, you're really intimidated by the idea of having to fix your prison system. And so through sharing between countries, we found that countries actually, even though they take a bit of time, they do in the end undertake measures that make things better on the ground.
So that's Europe.
Yeah.
How well do we know the situation beyond Europe?
So we didn't study beyond Europe, but I think it's really important to underline that a number of countries beyond Europe have not signed up, not to the European Convention, of course, because it doesn't apply, but to the UN Covenant on Political and Civil Rights. And in relation to that covenant, actually, when you look at the map, a number of countries have signed it, but what they haven't done is they haven't actually accepted that there's a court, or we call it a quasi-judicial body, so the Human Rights Committee, that has the power to hold that country to account. So it will not be able to be sued, let's say, or rule on a violation. So what that means is that when we go outside of Europe, and I'll say outside of Latin America, which has the Inter-American Court of Human Rights, you've got a number of countries that in principle have signed up these rights as ideas, as values, but actually when it comes to holding them to account, they haven't accepted that a body is allowed to do that. And so we have limited capability of assessing how they're doing on human rights. There are these reports, so we go through that, but there's really no way for an individual to take them in front of a body and say, my rights have been violated. So our capacity of assessing that around the world is not equal to Europe and to Latin America.
I said at the start of the podcast that your core argument in your lecture is that we should be hopeful.
Yeah.
I mean, it's kind of sounding, you're offering us a number of reasons for why we shouldn't be hopeful. So in Europe, yes, it's 85% on average, but well below that in some of the countries where presumably we ought to be most concerned about some of the activities that are taking place on the ground, and also concerns about what's happening in various other countries beyond Europe as well. Why should we be hopeful?
So I think, number one, I think international law is a long-term game, and we need to think about it as a long-term game. It can't just be the question of today. It needs to be a question of 50, 100 years. These are rules we've agreed to. But I argue in the lecture that really what gives me hope is that, A, we have international law, right? So we have this way of labeling what is happening today in the world, even if they're horrible things, atrocities. We are, after 1945, able to give these events a label. And even through that, we are doing already sort of half of the work by saying this is genocide, these are war crimes. And by giving that label, it really categorizes it as a crime. And it says these are the people who should be going there and collecting evidence, and this is the court that it should go to. So we are discussing it in the words of it going beyond something we don't like, but actually saying this is illegal. So it gives it more power. The second thing that gives me hope is really that in looking at the European system, what we did to understand what countries do in response to judgments, we actually went into the different states and we spoke to civil servants. And I want to underline, we spoke to civil servants in Hungary, we spoke to civil servants in Poland. So we spoke to people in countries where democracy, if you like, was under attack and where their hands may have been tied in terms of what they could do. But the belief that they had to do something, or the belief in human rights, the belief that they would find a way or that they would create a way, even if they had to wait 5-10 years for a new leader to be in place, that was still there. And so I really came out of this interviews with a sort of, not reassured, but with a feeling that over a long time, 20, 30 years, human rights and international law can go forward and it can provide protection and progress for the people on the ground because of the people working in these institutions. So that's my second point. And the third point is really my students and the people I've met on the ground mobilizing, using international human rights to bring about change. So that what we're seeing now in terms of climate change, what we're seeing in terms of Palestine, is really young people saying this is enough. We can't see this happening for the next 10, 20 years. It needs to stop. And that mobilization has created a lot of work for international lawyers, for people who are appearing in front of court, and for courts themselves. So the South African case in front of the ICJ, but also the kind of small island states coming together, right, to sue other states in relation to climate change and what has happened. that really came from young people who are saying we need to use the law to bring about real change to people on the ground. I think those three things, even in these dark times, for me mean that we're not stuck in a place where nothing will happen.
It's really interesting because when you were describing the second of those reasons there to do with civil servants and civil servants maintaining a commitment to these norms, even if political leadership in some countries does not maintain that, I guess my concern would be, well, maybe it's just that the leadership hasn't quite managed to purge the administration of all of these people yet, but they're on the way, and that at some point they will succeed in getting there, particularly now, I guess, that we see quite a shift in the kind of international language around these issues, at least in significant part in response to the election of Trump and the arrival of a very different kind of discourse coming from the most powerful country on earth, that would sort of enable and empower leaders who want to weaken human rights discourse around the world to go further and deeper in removing people who support these norms from their administrations. But I guess you're saying that, well, even if that does happen, then that third reason that you offered about kind of broader public support and civil society support means that, it's just incredibly hard for even these sort of authoritarian-minded leaders really to shift the norms that are underpinning all of this.
There's a lot of discussion at the moment whether, we should change interpretation, freedom of speech and allow for more conservative speech, whether we should renegotiate human rights, for example, here in the UK on the European Convention of Human Rights, whether we should withdraw from these kind of agreements. I think it is, or whether we should reinterpret what Article 8 and right to home, right to privacy means. I think in today's world, it's really, really difficult to get countries around a table to agree to a new treaty, a new agreement, or even a reinterpretation of the existing agreement. I think what we have, both in terms of institutions and in terms of law, is what we have. And in some sense, we need to fight to protect it and use it as much as we can. It is often very frustrating because it doesn't get you to an end result. But I think we need to work towards it. And in the lecture, I talk about how, I've got colleagues who are arguing cases, and then I've got colleagues where I count myself also amongst them, where we are arguing how the cases that come out, the judgments that come out of courts, how they should be implemented, how countries should go about putting them in place. And I think we need both of those groups of people to help really change things on the ground.
We've talked so far about some of the key arguments and findings in your work. Let's talk a bit more about your own path through life and the path that took you to this work. How did you get into this research area in the first place?
I would say in terms of research, I stumbled into it. So I come from, my dad was an academic, and so I always thought I would do a PhD. I didn't know that I would be an academic, but I ended up being one. But in terms of more generally human rights, I always knew I wanted to do human rights. And I think it's partly based on, where I come from. So I mentioned in the lecture that I was raised in a socialist state in the 1980s where, and I touch a bit upon this, but where, the freedom of speech was kind of limited. So there was censorship, there were books we couldn't read, there were things we didn't have access to. As an academic, my dad was not allowed to undertake specific kind of work, so he studied rituals and was very interested in looking at how religious rituals like celebration of Easter or Christmas would take place secret because you had to hide from the communist socialist authorities. And that, brought with itself a number of things like being followed or our walls being what's the thing in the lives of others? Our walls speaking. So our walls having microphones in them or our telephones, you not being able to speak whatever you wanted to. So I'd say that was one part of it. The second part of it was my mom has always believed that if you found a profession where it was a calling, you would never work a day in your life. And by going into human rights, I never feel I am working. You could say I work all the time, but in reality, it's just my life. And so I've been lucky to find a calling and to find that I can change people's lives through that. And then the third one, I think, is once I got to the UK and discovered this new way of thinking where you can be critical, where you've got all this knowledge that you have access to that we didn't in socialism. I think just a whole horizon opened up for me, and I learned to have my own opinion, which was a new thing for me, to actually be able to think and not just regurgitate what I had been told or taught. So I'd say those three things together brought me both to human rights, both to academia, and then to kind of thinking about how to use this to make a difference for people.
And do you think that background gives you a different perspective on these sorts of issues from those who've grown up, say, in the UK?
I think what it does is it makes them more alive. So I still remember the kind of, the feeling of a child. I had a wonderful childhood, but I remember the feeling of this kind of anxiety of not being able to say, anything I wanted because somebody might have been listening. And those kind of things, I think they shape you. And then you kind of find that what you do is more tangible, you feel like you want to make a difference to the person you're speaking to.
And you also know, as I mentioned in the introduction, you combine being an academic with being an ad hoc judge on the European Court of Human Rights. Firstly, what does that involve? What does that mean you actually do? And then secondly, how does that then in turn inform your academic practice?
So an ad hoc judge is a person who, when the main judge on the bench, this is at the European Court of Human Rights, is conflicted for whatever reason, an ad hoc judge will come in for them for that single case and will sit on the case, looking at the facts and then applying the law, and sit in the deliberations with the other judges.
So how often does that happen?
It depends really on who the main judge is. But what it gives you, I think, is you get these real cases. And I think what strikes me is really you see how hard it is to get to what we call justice. How many years, how many instances you need to get through to actually get, for example, to an international institution like the European Court of Human Rights, how much you need to fight to be listened to and to have your case heard. And then there's 3 people there or 5 people who decide whether you'll win or lose. So it's a humbling experience because you see, kind of horrible cases, and at the same time you've got the law. So you're constrained by the law, but you also feel you want to do something for the person who's there.
You've led us there very nicely into the new research that you're now embarking upon. So we've been talking about the research that you've done in the past, but you've just started a new European Research Council grant. What's that looking at?
So that is actually looking at what I was just in some sense describing. So I want to understand how people, it's called Break the Bias, and I want to understand how people get to these international human rights institutions and when they do and when they don't. So what are the obstacles when you're seeking justice? What are the obstacles en route, and how much do lawyers play a role in that context? And it was really triggered by this statistic that I found, that out of all of the cases that come to the European Court of Human Rights, only 25% are women and everything else are men. And it just, in some sense, it doesn't make sense. Why would there be such a big discrepancy? So I wanted to understand, what is it about women in a way that makes them not make these claims? Is it something about the law? Is it something about the lawyers you meet en route? Is it something about the psychology of the process and what kind of a strain it puts you under? So
how are you researching that?
So we are looking at all of the cases that are on domestic level that could be taken to an international level, and then determining which ones go up and which don't. And then we will go into the countries to talk to the lawyers of these people to understand why they didn't go up. And we're tracking them step by step, or if you'd like, instance by instance, to understand who falls off, what are the groups, what are the types of cases. And what I'm really interested in, is there an area of litigation that is not happening, and therefore it means there's an area of human rights law we don't have.
Is there already bias in the cases that could go forward? So is there already bias in the system at the domestic level, or is it particularly something that you see happening at the European level?
So there is bias at domestic level, but that has been thoroughly researched. So we have a lot of research on the domestic of who actually takes up a claim and makes it a legal claim, or who resolves things amicably. So we've got a lot of that, but we've never had a study looking at who goes to an international level. Because, and this really came about also because I used to work in Denmark. And in Denmark, there's this almost embarrassment if you sue your own country. So people will take cases to Danish courts, but when it comes to taking cases to Strasbourg, people will not sue Denmark. The only individuals who sue Denmark in front of Strasbourg are really migrants, because they don't have that feeling a Dane would have living in this homogenous society, that there's something about suing your own country that kind of is embarrassing. And so I wonder if there's a cultural element to it as well.
Gosh, how interesting. So I was initially thinking, when you said that this is already very well studied at domestic level, that presumably therefore you have some hunches as to what you're expecting to find at the international level as well. But you're also suggesting that potentially there are some particular mechanisms that work at the international level that don't work at domestic level.
Exactly. So what we know in terms of domestic level is that obviously legalizing your claim depends very much on whether you have money to get a lawyer. Lawyers are super important. And so it's going to depend on legal aid. It's going to depend, and if there's no legal aid, how rich you are, so how affluent you are, things like that. And that has been, we've analyzed things according to postcode, where you come, who the lawyers are they specialists, are they not? But when you internationalize, I think there's something else at play.
Fascinating. And how long do we have to wait until we get some results from this?
2030, 2031 is when it ends.
Gosh, okay. So
long term.
Well, hopefully we can have you on the podcast in the interim in order to hear how the investigations are going there. Just before we wrap up, though, we're coming towards the end of our time, but we've explored your career in various ways. We've explored the fact that even though there are problems in the world today, still you see that there are really fundamental reasons for hope. Final question. Lots of the people listening to this podcast will be young scholars, practitioners who are thinking about what path they're going to take in the future. What advice would you give them in terms of, if they want to do something in the world of international law, they want to make a difference to human rights? Is international law the place to do it? If so, how? What kind of paths are open to people?
So I'd say there are a number of different paths. You can try through an NGO, and there's a number of very good, excellent NGOs. You can try through a kind of legal route by becoming a barrister or a solicitor, and there are now very good, excellent law firms that specialize only in international law litigation. And it's not only between states. You also have arbitrations where you are representing or suing businesses. So it's very interesting work. You can go through diplomacy or politics by working for different governments. So I've just come back, as I said, from Geneva, and there I met with a number of different diplomats and representatives of country, and they work in Geneva really to make the system better and to really uphold rights across the world. Then obviously there are international institutions, and I think they are still looking for people, even with the budgetary crisis. They want good people who will deliver on the promises. But I'd say whatever route you choose or you try, I think one thing I learned is don't give up, because international law, there's a lot of people, there's a lot of, there's a lot of discouragement. I think you want to create your own way. You want to find your own route. I found that route through academia, but having worked also at the same time at the International Court of Justice, European Court of Human Rights, at UNESCO. So I tried out different things before I decided on academia. And I think this trying out, but really insisting on your own path is what really worked for me. I think the lesson for me was never to give up. and to insist and to find another way, another creative in, and to create those ends for yourself. I've got friends who, became barristers and found clients and created cases out of things that other people didn't think were a case. So it totally depends, I think, on someone's initiative and persistence.
Well, thank you so much, Veronika. And we're so glad that you have persisted and not given up, because you're doing incredibly important work. And it's really wonderful to have you as a colleague here. So thank you so much for sharing your career and your research and your insights with us today.
Thank you, Alan.
We've been exploring the career and the research of Professor Veronika Fikfak, Professor of Human Rights and International Law here at UCL. And if you want to hear more, you can watch Veronika's inaugural lecture, which was delivered in the spring. You can watch it online, and we'll put the link in the show notes for this episode. Next week, we'll be looking at the relationship between immigration, housing policies, and support for the far right. Remember to make sure you don't miss out on that or other future episodes of UCL Uncovering Politics. All you need to do is subscribe. You can do so on Apple, Google Podcasts, or whatever podcast provider you use. And while you're there, we'd love it if you could take a moment of time to rate or review us too. I'm Alan Rennick. This episode was produced by Eleanor Kingwell-Banham and Kaiser Kang. Our theme music is written and performed by John Mann. This has been UCL Uncovering Politics. Thank you for listening.